Hey everybody, Dr. Shawn Talbott here. Hey, we're going to talk about patents today based on a question that a friend of mine sent me recently. In the natural products industry, it's actually very difficult to get a patent because the patent office, in order to get a patent, it has to be something that is novel and unique. And it has to be something that doesn't exist in the world. And importantly, it has to be something that someone who is skilled in the art wouldn't have already thought of before. So, let's say you have, one interesting thing and another interesting thing, and your idea is to put them together. That can't be patented because that is something that somebody who is skilled in the art, like of natural products, probably has thought of before. And so that is not patentable. So it's difficult to get a patent in the first place. It's very difficult to get one for a natural product because of what I just said, but also for the fact that the patent office takes sort of a default position that things that are in the natural world can't be patented. So you can't patent a particular plant unless you significantly change it to make it novel and unique, and the language is non-obvious. So this question came into me from a friend of mine. He says, he wants to pick my brain. It says, an acquaintance in the U.S. is developing a mineral vitamin that is naturally derived and is getting lab testing results back at the end of the month. When would you recommend patents? What are some pitfalls to look out for when launching this product? Any general advice that would help him in preparation of launching his product? And what I replied back to him was, hey, maybe you don't want to get a patent at all. For the reasons that I just said, if this is a natural mineral blend, it might be coming from a unique source, right? There are mineral sources where you can get from, the Great Salt Lake or some ocean situation. There are minerals that are deep ocean mineral sources that have been commercialized as dietary supplements. There have been mineral sources from bogs all around the world. There are mineral sources from like Arctic glacial runoffs. There's mineral sources from lots and lots of different places. So the source could be something where you say, instead of patenting it, you might want to make it a proprietary blend. You might want to make it, like think of Coca-Cola. The formula for Coca-Cola isn't patented, but it's proprietary. It's a secret formula that you can only get if you drink Coca-Cola. And that's a different formula than if you're drinking Pepsi or you're drinking, something else. So, that's a different strategy, but sometimes that is the smarter strategy than patenting. One of the downsides to patenting is that you have to basically lay out you have to describe your invention in enough detail where somebody else can practice it, meaning somebody else could do the same exact thing. And therein lies another problem. So because you have to do that, you have to describe the invention at such level of detail that somebody else could do it. They're prevented from doing it if you actually get the patent, but that's up to you to defend. So the government isn't going to go after somebody if they're infringing your patent. You have to go after that individual or that company. And that's where a lot of the problems come in. So patents are very hard to get for the reasons that I said. They're expensive to get because there's a lot of really smart lawyers that charge lots, very high fees to do these filings. So let's say you even get a patent, and I have several patents in the natural products industry, and I've filed dozens and dozens of them. I'll explain why in just a second. So let's say you go through all the expense and time and effort, and you actually get a patent. Now it's up to you to defend that. If you find somebody who has copied you and is doing the exact same thing that you are out there in the world, you have to sue them. You have to bring a lawsuit. You have to take them to court, and that's very expensive. I've been an expert witness on a lot of different patent infringement lawsuits in the natural products industry, and it's really, really difficult because that infringer could be saying, well, we're extracting our herb in a slightly different way that doesn't infringe the patent. But it's up to you to prove that. To prove that they're infringing. It could be that you have a combination of, herb A and mineral B and vitamin C, and not actually vitamin C, but you get the idea that for some reason you got a patent on, and somebody else could be doing the same thing, but they're using a milligram or 10 milligrams outside of the ranges that you disclosed in the patent. So technically they're not infringing anymore. So it can get very, very complicated, and to actually bring that to litigation is very, very expensive. In fact, all of the patent infringement lawsuits that I've been a expert witness on have settled before they've gone to actual trial because it's so expensive to do. So why would you try to do this anyway in the first place? Like, I have a few. In fact, one of my patented blends is going to be in an upcoming product that I'm launching in a couple of weeks. And we were a little shocked that we got it. It's a pretty broad patent. It's going to really protect that formula that we're going to be launching. So it's going to be really, really good for us. But you very often will file a patent not even thinking that you might get it, right? The reason that you would do that and go through the process is because it puts up somewhat of a wall against your competitors for them to at least think, that's a good idea, but if it's patent pending while the process is going through, you haven't actually gotten the patent yet. If it's patent pending, it might give them a little bit of pause to say, maybe we don't want to knock it off, because if they did come after us, there's something called treble damages. So let's say I launch my patented blend in a couple of weeks, and somebody tries to knock it off, somebody knocks it off, and we can prove you're doing the same exact thing that we have patented. If we win a lawsuit, they would have to pay us triple damages. And if the damages are they sold $1 million worth of their product, we could claim that they owe us $3 million in damages. So it could be very costly for another company to try to infringe your patent. And so a lot of times what you'll do in the natural products industry is file your patents around your formulas, and you keep them pending for as long as needed until you might reach a point where you say, it's not worth it for us anymore. The sales of the product are not what we expected. We've changed the formula of the product because the natural products industry has an aspect of fashion to it, where like something might be hot for a period of time and then it goes out of fashion, and people are looking for different things so your patent isn't that valuable anymore. So lots and lots of pros and cons to the patenting process. So what I recommended to my friend's friend is that this proprietary formula approach might be the better way for them to go, to say, here's our mineral blend, here's why it's cool and why it's different. And then market that to your customers. Say it comes from a unique source. It's a combination of minerals that you can't find anywhere else. They do X, Y, and Z in the body. They have these health benefits, et cetera, and we're the only place that you can find it, right? Make it as proprietary and unique as possible. And here's how it's differentiated compared to those other mineral supplements that are on the market. That might be the better approach. The only caution here is that, going back to patents again, is that there's something else with the patent landscape that is called an on-sale bar, meaning once you offer it for sale, then it's no longer patentable. So you have to make that decision to patent or not patent before you offer it for sale for the first time. And so a lot of times what I'll say to somebody is, you can file something called a provisional patent, which is literally just a one-pager. Really cheap to do. Most lawyers can do it in a couple of hours and file it with the patent office. A lot of people can do it themselves. And what you do is you basically put a flag in the ground, right? A line in the sand to say, I'm declaring this patent right now. You give enough information for it to sort of be like, here, I'm going to do this before I start selling something. But then you have to come back within a 1-year time frame and file a real patent, a real utility patent. Again, pros and cons. A lot of times in the natural product space, we'll have a formula that has to launch for a launch event that's coming up very, very quickly. So sometimes we'll file a provisional, we'll launch the product, we'll see how it does for the first year, and then we make sure, we make a note that we come back before 365 days have gone by, and we convert that provisional patent into a real patent, if it makes sense. So you could always do that. File a provisional, cheap, easy. It gives you the option to then start selling your product, and then gives you another year to decide if you want to go through the time and expense expense of filing a real patent. So anyway, hope that helps. So if you find something in the natural products industry that is patented, it's a pretty unique thing. You might want to take another look at it because it might be something interesting. It might be a patented process of extraction, so you end up with bioactives that are different from the non-patented versions. This patented blend that we have launching in a couple of weeks is a patented blend of a pine bark extract and a green ephedra extract that have known things individually, but when you put them together, they do some very unique effects. They have some really cool benefits, sort of gut-brain axis benefits. So we'll launch that, and that's something that is a unique, non-obvious, really cool invention that has been allowed by the U.S. Patent Office. So anyway, that's the patent landscape. I hope that helps you guys understand what's out there in the natural world. Okay, see you next time.